Hello, lovies. Happy Easter Sunday, April 20th, 2025. I hope that you had a wonderful day with your family if you celebrate, and that you had an opportunity to really reflect and pray and think about what we are looking for in the coming months and what is important to us, and how you can use your strengths within yourself and via God in order to push forward in everything that we do. And that's always how we support one another and how we show up for each other in all aspects of life, whether it's as a parent, potentially as an employee, as a daughter or a son, and even as a friend. So today, I am thankful for tiny Jesus who resurrected for me. And I am also thankful for one of my friends who I have met along the way, who means a lot to me, and who decided that he would be able to share some time on his Sunday to, just bring us to a better place, as he always does. The incomparable Attorney Mark Bederow.
God, that was so deep. I don't know what to say, but you can't ruin my Sunday. The Celtics won. It's, ate an early dinner, and here I am. So
I love that.
Easter. Yeah.
Thank you so much, Mr. Bederow. And it means a lot, because I know Sundays are a day for family, and a day, especially for, whether you're Christian or Catholic or anything, sometimes everyone is probably tuckered out. You've had a day, but they can listen to the soothing sounds of Nurse Kim and Attorney Mark Bederow.
They have nothing else to do than God bless.
Oh, I love it. Oh, and let's say hello to our friends. Hi, Kate.
Hi.
And we have a CM Laval. Hello, Mark. Good to see you. Yeah, no one is happier than me that you thought you would bless me with your presence today. And Kimmy says, Happy Easter, Mr. Bederow. Love when you visit and share with us. He's the best.
That's nice.
So we are gearing up for Commonwealth v. Karen Read 2.0, scheduled for opening statements on Tuesday, April 22nd. And I mean, we had a wild week, as we always do. It sometimes feels as though it can't get any more off kilter, Mr. Bederow, but it always seems to. So there was a lot that happened at the final pretrial hearing, and specifically the breakdown of Hank Brennan from the podium was quite shocking to me. And this is related to Aiden Turtleboy Carney and the Fifth Amendment assertion. And I just wanted to get your take on that, if you could.
Well, I mean, the Fifth Amendment thing, that was always the way it was going to be. And that's just common sense, being a lawyer. So the idea that he was ever going to be excluded from the courtroom or sequestered was never going to be was just never going to happen, because he completely has a valid right to take the Fifth. It doesn't mean what a lot of the court TV experts believe it means. What it means is lawyers are paying attention, protecting a client's rights, and not giving the prosecution and another prosecutor the opportunity to interpret, twist, and use things against him at a later date by calling him as a witness now. So I don't know why this was something they ever thought was going to happen. It was never going to happen. This is just a ground ball. I mean, from a lawyer's perspective, if you don't advise a client to take the Fifth who's under indictment, and they say they want to ask him questions about the subject matter of the indictment, to be a lawyer and allow that to happen at someone else's trial, not testifying on his own behalf, that's the kind of thing where you have to call your malpractice carrier in advance and say, am I covered if I do this? I mean, I'm kidding, obviously, but That's the point is,
Right.
this is a complete no-brainer. It's just silly that this had to happen in the first place because they were never calling him as a witness.
Mhm.
He was clearly there as a way to at least attempt to try to exclude him, keep his speech stifled, if you will. Even when presented the other day by the court with an opportunity to explain whether he would be testifying in their case in chief or on rebuttal, you got a lot of humada word salad from the DA on that because they know it's a joke. They have a history of doing this, or at least the prosecutor personally has a history in prior cases of using this tactic to try to suppress speech from reporters who are not friendly to their cause. So it would never happen. It's just the most obvious assertion of the fifth, or prospective assertion of the fifth, indicating he would do that. There isn't a lawyer in America who would not advise a client to do that. And the only people who question it or read into it are the types of people who have, turtle derangement syndrome and just hate him rather than the concept of the fifth. And that's okay if people don't like him. A lot of people don't like him. But if you can't accept, legally speaking, that this is a valid claim without reading too deep into it, that it means he's a pussy or he's guilty or this. I mean, the only people who would credibly say that are people who just have opinions about this case that no matter what are going to translate anything against him or against Karen or people who appear on court TV. I mean, that's just the way it is. But this, legally speaking, is a joke.
Right. And I felt as though Judge Cannoni was kind of sick of of Hank Brennan as well. Did you get that sense from in the courtroom from with that specifically? Because she was like,
yeah, I mean,
yeah,
she obviously understood the issue in the sense right away. We filed a motion which argued numerous things, but indicated, that the Fifth Amendment ultimately would carry the day. But her first question was, would he plan to take the fifth? Which means she understood the issue. Everyone in the courtroom, including Brennan, understood that there's a valid claim to take the fifth, which is not the way it's defined by the Wendy Murphy people and the people from the island of the misfit toys. It's a valid claim. Everyone understands that, and once it's established that we all agree, the judge would have expected the DA to do exactly what Tim offered, which was, I can represent, he's going to take that. We said it in our motion. I said it today. That's the way it's going to be. And 99% of prosecutors would accept that. But as you know, this is the 1% kind of case. And, he wanted his pound of flesh or his courtroom theatrics or drama or whatever, please other people that support him to have him get up there. And the judge was never going to do that. I mean, all she had to do, you call someone up, call the lawyer up. Would he take the fifth? Can you explain what would happen? She recognizes the issues. They don't make a judgment. The judge doesn't say, oh my God, he's definitely going to incriminate himself. The issue is whether there's a good faith basis to take it. I mean, the only role of the judge is to make sure that someone is not just claiming they're going to take the fifth to avoid testifying. The reality is the DA and the special prosecutor, in this case, they're too clever by half. I mean, they've made such a big deal that, they believe Aiden's a criminal. They believe he conspired with Karen Read. He's under indictment for 18 counts. They're alleging that he's still under investigation with her for the exact conduct in which they want him to testify. So you're telling me that this is some big earth-shaking analysis that, oh my God, he's afraid he must be guilty? No, he's listening to lawyers who say, why would anyone in these circumstances testify and even allow them the opportunity to twist, turn, misinterpret? And by the way, if you look at this case in the last several months, do you think this prosecution team is capable of twisting, turning, misinterpreting, doing those kinds of things? I would suggest he was pretty obvious. So it's all much ado about nothing. I saw the segment on Court TV the next day. that was one of the most embarrassing legal analyst sessions between, what was it, Julie Grant and Wendy Murphy. That was just, I mean, the analysis that they were putting out and what it meant and how important it was and what it suggested. It's shocking that those are two lawyers, two former prosecutors, mind you, having that discussion. I just thought it was intellectually dishonest, and just certainly they have to know how silly as lawyers they sounded.
Yeah, the use of their vocabulary as well on, I mean, do you think that that's cool to say on court TV that Turtle Boy, you would like to refer to him as a turd? Like,
Look,
what are we doing?
Wendy Murphy is a cartoon character and an embarrassment and disgrace to the legal profession. So the issue isn't whether she says these things that are offensive. The issue is, why would court TV platform someone who has been sanctioned multiple times for putting forth frivolous arguments, for advocating nonsense about the Duke lacrosse case that everybody knows from years past, for being the queen of bad legal takes, as we all know, and just spouting nonsense. She purports to be a feminist rights type attorney, but she's also mused about Karen getting raped in prison and thinks that's funny. She's just a complete embarrassment. Okay. She's just the kind of person that you should feel sorry for. I mean, as an attorney, I feel sorry for her that she is so ignorant, or is it an act? I don't know. But she ought to be just ignored, not platformed. And so the real question to me is, it's a court TV problem more than a Wendy Murphy. Wendy Murphy is going to be the clown, is going to be the cartoon character. If anybody's willing to listen to her, she'll do it. I mean, she's going to run around as the court jester and do it her own way, whoever's willing to listen. She does it on Twitter. She does it on court TV. She does it, in her writings, wherever she's going to do it. The real issue is, why would court TV put her on? That they look like the fools.
Yeah, and Julie Grant as well. We discussed this I discussed it with Melanie and Will yesterday, and Jimmy before he got off. But we were just saying that her show specifically, there is a place, and there is a spot for the family and friends of Officer John O'Keefe to tell the public all of the stories that they would like to share. But when you have that vitriol within themselves that is represented by Julie Grant in such despicable ways, in my opinion, it's just it's very inappropriate.
I mean, Julie Grant is not an unbiased host, whatever the word is.
Yeah.
She speaks about the witnesses as innocent people. And they may, look, you can have your opinion, but when you're a host, you got to put it down the middle. And she vouches for the Alberts, the McCabe's, and those types as innocent victims, witnesses who did not take the fifth. They're just innocent people who were called. And again, she's allowed to think that. But the reality is, a central issue in this case is whether they are. And she's fully entitled to her view. But when you act so-called neutral observer, to sit there and say, well, this guy is the only one who took the fifth and we know what it means, but Brian Albert and all these other people, it's not her place to do that. And when and you can also judge a person by the company they keep.
Yes.
When you company with Wendy Murphy and Coffindaffer and the rest of these people, you're revealing yourself. So, and she does have a background as a prosecutor, but she's also not willing to take contrary viewpoints. I mean, I didn't even know who really she was when I was watching the first trial. But I remember this specifically, after the EMT McLaughlin testified. And if you recall, there was this issue of, friend versus acquaintance and whether she was playing it too cute. And of course, my view at that time and now was, listen, it's okay to call this woman a friend. You're just digging a deeper hole and you're discrediting yourself by arguing, this nuance between friend and acquaintance when it's clear you're friends. It doesn't
Yeah.
mean you did anything wrong. But when
Of course
you
not.
protest that much, you reveal yourself.
Mhm.
So Julie Grant back then issued a tweet or something about how silly this was, and this was the defense, making too much out of this, and this was insignificant, and they're overplaying their hand. And I responded to her comment with something, just, I don't agree. I don't remember the exact words. Just something like, no, this is actually can be very devastating
Right.
to this witness's credibility, because if she's willing to split hairs on something that ought to be trivial, it's going to lead a jury potentially to wonder, if she's willing to, cut that line so fine, what other things might she be willing to fudge? And she blocked me. Now, this is a year ago. This is early in the game. And I just thought, what a fraud. I mean, just look, you're a lawyer. I'm a lawyer. Let's have you're a former prosecutor. I'm a former prosecutor. You have a big platform. You're advancing this argument. I don't agree with you, lawyer to lawyer. You obviously put that opinion on Twitter. You're inviting responses, except in reality, she was inviting responses that would agree with her. And
Yeah.
that to me is unprofessional. And when you watch these episodes and you watch these shows, again, the biggest criticism you can give to a TV host or an anchor is bias.
Yeah.
And her bias is just off the charts. I mean, when you're sitting there with Wendy Murphy yucking it up about only one person took the Fifth Amendment, and we all know what that means, and you're both legally and factually sounding like morons, and you have someone saying, "Can I call him a turd?" And I mean, it really reflects poorly, though, not on her, on the organization of Court TV. And I feel bad for the good people at Court TV, but they platform continuously a lot of people who really probably they shouldn't, to be kind.
Right, that they should not be on a television set in anyone's living room and anywhere else. I had a very interesting take, or I saw of Wendy Murphy, was that she has now, and she has for a while, I think a lot of people have picked up on it now, that she is alleging that Officer John O'Keefe, in a fit of rage, Mr. Bederow, okay, threw a cocktail glass at Karen Read's taillight, and that, and then he kicked it. Right now, she's saying that he's drop kicking her vehicle. So you're actually alleging that there was some sort of domestic violence on the behalf of the decedent. That is, and who are a victim of untimely death of Officer John O'Keefe. It is wild, and I see the anti Karen Read people jumping on this, like they say, oh, absolutely, anything that Wendy says, they say it's yeah, oh, okay, I get where you're coming from, that makes sense. That doesn't make any sense.
Well, it doesn't make any sense. But also, if Wendy Murphy is the leader of and I'm not into movement. I'm just a lawyer giving analysis. I'm not part of a movement. I'm not Karen Read. I'm a lawyer who thinks she's getting screwed in a criminal case, was invited to help try to, establish that and whatever. But I'm not, I don't go to standouts. I don't donate money. I don't scream and yell and talk about McAlberts and Auntie Bev and all. I'm just a lawyer giving analysis. But I mean, I'm biased in the sense that I have sympathy towards the fact that I think that this case is a disgrace. But to the extent that there are sides and people choose sides, if Wendy Murphy is a leader of your side, you've already lost, because she's a joke. I mean, she is as close to a cartoon character as you could ever have. And if that's the person that you need as your legal analyst to attempt to steer you to make these arguments, then, it's probably time to find something else to go. You have to also understand, she makes these statements on Twitter, and she And she gives no quarter. She makes these factual assertions of this is what happened, and if you don't agree with me, you're a moron.
Yeah.
The problem is this current version, by my count, is version number 3 or 4, each of which is inconsistent with the prior, that she has stated emphatically is what happened. I mean, there was the plow scooping him up, there was the
Yes.
scratches on the arms, there was this, and now it's, you know, that whatever she's describing, how apparently John O'Keefe was luring Karen out of the car with, I have an alcoholic drink, as if, you know, he's the Pied Piper and that's going to, you know, put her under the spell to follow him out. And he's holding 2 drinks and he throws one and does this. And look, Wendy Murphy should just be ignored. She is an expert in nothing other than just profound stupidity in legal and factual analysis. And that's just the reality. So, you know, maybe she's a nice person when she's not like acting like a clown on Twitter, which, you know, is what she does. But credibility matters, okay? She's been sanctioned multiple times for making frivolous arguments in court, not on Twitter. She certainly has made many frivolous arguments on Twitter. She's the queen of bad legal takes. She's the queen of the worst take in probably criminal procedure history, being the Duke Lacrosse case. At some point, somebody, you know, on the other side, I hate talking like that, but the way
I'm sorry. Yeah.
No, it's not you. I'm just, as a lawyer, I don't look at it that way. You know, not lawyers shouldn't look at it that way. If you truly believe that, you know, justice for John O'Keefe is Karen Read getting convicted, I don't agree with you, but if that's your view, that's fine. Find somebody better with a law degree than Wendy Murphy, okay? Find somebody better than, you know, the guy in the attic to be your, you know, source of information, and I gotcha. There's got to be somebody more credible without these kind of skeletons and just what I would call catastrophic discrediting traits that could argue their case. But apparently maybe there aren't. You know, if it's Wendy Murphy, Coffindaffer, and the guy in the attic, maybe it's you people. Maybe you're just wrong.
Yeah, like that's definitely something that potentially there could be some reflection there, right? An internal like look at it. And I understand your derangement syndrome and or your hatred for a defendant, which is mind blowing. They do also have Jafar, who I refer to him. Big Mike Jafar is Jafar from Aladdin in my book. He's a villain. Because he has wished, not only he has said figuratively that he wished Karen Read had enough figurative rope to hang herself with it after Mass State Trooper Michael Proctor had wished death upon her. If she just had ended her life, things would have been more simple. And that's another legal analyst that has been asked for their opinion. I did find Catherine, I was going to say Linehan, and that's terrible. That's Kevin's last name, but Catherine, she's Note Your Objection on TikTok. She is the WBZ analyst, and she actually had a pretty middle of the road take. She has gone from more like F around and find out that Hank Brennan is going to be a problem for the defense to now saying that she believed it would be the best bet for them to really hone in on Mass State Police, specifically Trooper Proctor, and all of that situation, the lack of investigation, and steer clear of third-party culprit, because then we're changing by nature, right? We have our prosecution who has the burden. Are you shifting the burden, Mr. Bederow, if there has a third party culprit that is introduced just intrinsically in a jury, like how their minds work when they're rationalizing and going through evidence?
Well, it depends. It depends on how you do it. I mean, to me, third party culprit, the term of art, and the importance of whether it's admissible or not. And I've said this before during the first trial and certainly the lead up to next week. It's really semantics to me. It really is just a layer to the so-called Bowden defense that they use. and reasonable doubt. It all goes hand in hand. So do I think that they ought to say, it was Brian Albert with the candlestick in the conservatory? No, I think that's a bridge too far. And I think some of that you saw at the first trial was, a bit too much. But logically, it is a third party culprit defense in the sense if Karen Read didn't do it, somebody else did. And that doesn't mean that you certainly don't want to assume a burden that you don't have to take and prove it who did it. But if you're arguing that she didn't do it and that's supported by science and that's, the ARCA stuff, which leads to the planting of evidence by most likely, if you believe that, a trooper who has since been terminated for being a scumbag and having bias against Karen. And Correct. It leads to a relationship with this other group of people. And then this other group of people are sending butt dials, weird texts, weird behavior, doing all kinds of weird things, obsessing over, let's get our stories straight. Let's make sure we control this. Let's not talk on text, which is not an innocent thing to do. Jen McCabe Googling herself, that's kind of an underrated part of this, with
that is,
she was Googling herself in those early morning hours in the day after. Why? That's weird. What are you worried about?
And right after Officer John O'Keefe, she was Googling John's name and then hers.
Am I getting linked to this? That's all weird.
Yes.
Now you could say that's just narcissistic. That's any number of things. It doesn't prove she's guilty. The point is, if you're arguing that the ARCA stuff establishes reasonable doubt, she didn't do it, then you're putting this out there and you say, look, I don't know who did it. I know who didn't do it. She didn't do it, ladies and gentlemen. Now, could it have been these people in the house? Why are they acting suspicious? I mean, I would argue, I don't know what they did or didn't do in terms of a homicide, but I damn well know what they're doing is not innocent, explainable conduct by normal people who claim they slept through this. Okay. That's not normal. And what they were doing the next day with those text chains and tell them the guy didn't come in and they're looking over here and they're doing this. That's not normal. That's indicative of being concerned about something by people who have nothing to be concerned about. So I think there's a better way to argue it than saying, oh my God, they were in the basement and Brian Albert did it. So I don't need the third party culprit in a literal sense to say what I just said for a summation. Does it factor? Sure, it does. If you want to argue that those are dog bites, absolutely. Because if they're dog bites, the point is it's not consistent with a car accident. That's the primary point. It doesn't have to be dog bites. The real point is, and this is all burden of proof, and if it's too much in the weeds for non-lawyers, you'll tell me.
No, it's perfect.
But the point is the arm pictures that, they're going to elicit evidence are dog bites. That's a secondary issue. That's an important issue. Obviously, if the jury thinks those are dog bites, that's a huge win for Karen. But the larger point is you don't have to know they're dog bites. What you need to know, ladies and gentlemen, is that there is a lot of question to support the argument. It ain't from a car and a taillight sideswiping a guy at 20 miles an hour. And if it's not that, it has to be something else. And if it has to be something else, it's not Karen. And if it's not Karen and it's one of these people, we don't have to solve that problem. The only thing you have to do is she walks out of here because she's not guilty. That's it. So the whole third party culprit thing is just, to me, has never been that big a deal standing alone. It's a logical progression and part and parcel of a reasonable doubt defense, if that makes sense.
Yeah, that totally makes sense. And thank you so much, because honestly, Mr. Bederow, I know that I say this to you every time, but like having these conversations with you and it is like literally priceless, because your ability to break things down and teach to us, which I know you're like him. I didn't sign up for being a teacher, but you have, I believe, taught me more in the last year or more than I would have ever been able to like get or gather independently, right? Other than being in college or taking courses. That's how incredible you are at this. And it's a gift and you have it.
Well, I thank you, but if you do this for a living, as a sideshow to my thriving real estate practice, you get a sense for what a case is worth, and there are conviction cases and there are acquittal cases, and there are some that are kind of, who knows, and criminal lawyers who do this for a living generally have a good feel. This is clearly an acquittal case. Now, it doesn't guarantee there's an acquittal, but this case has such hurdles for the prosecution that they're never going to get by because of the burden of proof. Okay, it's not going to be good enough to say, well, there's a solid piece of evidence which we think helps us and shows that she's guilty. They need to destroy the defense arguments. If any of the defense arguments are plausible on material issues anyway, then she's not guilty. So like when you get to like the science and the ARCA and all that stuff, they need to convince the jury that the ARCA witnesses, not that they might be wrong or our witnesses are better than yours. They need to kneecap, destroy, and eviscerate the ARCA witnesses such that the jury is left in the deliberating room saying, there's no reasonable view of the evidence that the ARCA guys are right. If there is any view of the evidence that the ARCA witnesses are, it's possible, it's plausible, what they said could be true, it's reasonable. Yeah. Well, if it's reasonable for the jury to believe what they said, which is the car did not cause, based on the damage to the car, did not strike John O'Keefe, and based on the damage to John O'Keefe, the car did not strike him. If the jury believes that that's reasonable, not compelling, but that's plausible, then we're done here. It's over.
Yeah. Totally agree. I also, yeah, no, that you're 110% right. I also was thinking too, Mr. Bederow, that when I think about it, just as a medical professional, right? The injuries, I know that I've told you this several times. All of our lovies know this, but there has been no, in real life, IRL, either physician, nurse practitioner, physician's assistant, any of the therapies, PT, OT, respiratory, anybody, nursing, in any specialty has never said that the injuries that I have described, right, not just his Officer John O'Keefe's abrasions on his right upper extremity, because that wasn't fatal. It's the 2.5-inch laceration to the back of his occiput in his cranium. And for there to be no blunt force trauma alleged other than a head hitting a frozen ground per Trooper Paul, and now allegedly a neurosurgeon from Florida, no one's going to be able to get behind that. And this is where I have stuck to my guns and said, it does not matter what Karen Read said when she was in a PTSD, trance, after coming upon a scene of finding someone you love unresponsive on a lawn, attempting to provide CPR and life-sustaining breathing for him. Then she gets transported to that hospital. I don't give a shit if she said, I might have, punched him in the nose, or I hit him with my pocketbook. I did something to him. I don't care, because Officer John O'Keefe's body and his autopsy proved to me she didn't.
So stop being so reasonable, okay? The problem with a lot, not all, but most of the people, again, who are the so-called antis, is exactly the opposite of what you're saying, but you emphasize the key point. They pounce on this, did I hit him? Did I hit him? Type stuff.
Yeah.
And that, again, in a courtroom is going to be much less reliable than expert scientific testimony for a lot of reasons. Number one, because science is science. Number two, if she thought she hit him, that may speak to her state of mind. It doesn't speak to what happened.
Amen.
Okay? There's a difference there. And without even getting into her mental state, emotional state, and other things that she was doing, which was consistent with attempting to save his life, like you said. When they pounce on that, but she said, did I hit him? Did I hit him? Maybe she thought that. I don't know. It doesn't matter. The science is always going to be the more credible evidence. But again, if you're sitting in a jury room and you're saying, the science is telling me it could not have happened, but the defendant is telling me she did it or thought she did it, and you're weighing this with a burden of proof that's reasonable doubt, this is a no-brainer. That is, on every law school exam you would ever take, in any common sense evaluation of the evidence, if you follow the judge's instructions on reasonable doubt, that's clearly reasonable doubt. And reasonable doubt can even be, I'm not saying it's the case here, but a jury could very well say, she's probably guilty. That's reasonable doubt. That's not proof beyond a reasonable doubt. Probably isn't good enough unless you satisfied that there's no reasonable explanation to the contrary. And if you can't exclude the science, which is inconsistent, by definition, that is reasonable doubt. So when you hear all these people screaming and yelling on Twitter about how guilty she is, try this. I mean, I did this months ago and, they went crazy. Don't cite facts that you think support your position. Tell me why that's proof beyond a reasonable doubt in light of the other facts. And again, that's when you lose them, because they're not, I mean, not all of them, but a lot of them, they're not serious people. They're either uneducated or biased, or they're not interested in analyzing it. Okay.
Right.
It's fine. It's fine to think she's guilty, but that's not what a courtroom does. That's not what a trial does. The only function of a trial is to determine whether she's guilty beyond a reasonable doubt. So saying, I think she did it, that as a lawyer, that means nothing to me. I mean, literally nothing, as does innocence in a courtroom. That's another thing. The trial is not to demonstrate how innocent Karen is. That comes after, when she's acquitted and she does whatever she does. But if these people who scream and yell about all this proof in their mind that means she did it, challenge them to say, how does that satisfy the burden of proof? That's how trials work. And these are the same people who, if it was one of their loved ones or anyone other than Karen, or or someone who is supported by somebody they despise, shall remain unnamed, the goalposts, they move. You know what I mean? Like it's just result oriented, and the bias is too much. If they're not going to have that serious discussion with you, then I wouldn't even listen to these people, because they're not serious people.
Yeah. Yeah. It just feels, unfortunately, the lead up to this trial, there was so much that was unknown to us, I believe, in 1.0, right? And when attorney David Yannetti got up with that incredible opening line of his opening statement of Karen Read was framed. And then all of the information that he jam-packed into that open, which in my opinion was proven throughout the entire 9 weeks of the trial, every word. But it feels like we don't have like any unknowns, in my opinion, Mark. I feel like I know this case now so well that yes, there can be different things that are going to be able to come up that maybe we are unaware of on the defense side, but prosecution wise, this should not be some sort of exercise in an ability to stretch or change theories because you are trying to persecute a woman. And that's what it feels like.
It does. And you saw something in court last week, unrelated to the Fifth Amendment thing, which should tell everyone and expose what this really is. I mean, you saw an argument. I mean, some people have called it a tantrum, whatever. Lawyers get pissed off at time and they get emotional in court. Whatever. I don't care about that. But what you saw was a prosecutor, by the way, not a defense attorney, a prosecutor whine to a judge that if you let these ARCA witnesses testify, they must be restricted to the four corners of their opinion that was formed all that time ago. By the way, we all understand, without seeing some of the evidence that, according to the prosecution, they should have seen. Now, the irony in that is, I believe some of that evidence wasn't considered by the ARCA people because the feds didn't have it, because they're rolling subpoena to the defense, which you're now aware of. The defense didn't have it to give it to them. And in fact, that's the DA's fault for untimely disclosure. Putting that aside, okay, then you get this opinion by these experts, and the DA this time does something better than they did it the first time, which is, instead of just relying upon this Trooper Paul, who is the single most unqualified so-called expert I've seen in 26 years of doing this.
Yeah.
Whatever. I mean, that the facts are what they are. We're not here to hurt feelings. I mean,
no,
he is not qualified to give the testimony that he gave. It was embarrassing. So they go out and they get this other firm who renders an opinion. Now, there is not a defense lawyer, a competent defense lawyer anyway, in America, and obviously these people are very competent, who would not take that opinion that they got from the prosecution, read it, digest it, and then throw it at their expert and say, tell me what you see. Am I concerned? Does this affect you? Are they wrong? What are they missing? What did they, whatever. Okay. And he's up there whining, saying they shouldn't be allowed to do that. That is one of the most embarrassing, revealing comments a prosecutor I've ever heard a prosecutor make, to literally say that they're not allowed to have their expert, in essence, rebut.
Yeah.
Expert, okay. And if you are so insecure or concerned in your own expert that I mean, this is how trials are. They're battles of experts.
Of course.
You know, they did this, by the way, at the first trial. If you remember, when they were talking about cell phones, I know this because I was there. It's actually the day I was there.
Yeah.
You know, they had their two witnesses, and the prosecution witnesses, Hyde and
Whiffen. Yep.
And they were asked about the defense expert's report. And, you know, and they were allowed to just kind of
opine on what they thought about that report. Yes.
And to see a prosecutor, okay, who is a minister of justice, by the way, first and foremost, the white hat guy, not supposed to be the guy trying to limit the defense from presenting what could be compelling exculpatory arguments, okay? They're allowed to do that. I mean, it's still America, even in Norfolk County. You know, the defense is allowed to argue. There's this little thing called the Constitution, the Bill of Rights. They're allowed to do this kind of stuff. And to hear a prosecutor in a case of this magnitude on TV sit there and say that it's too late because I'm not going to be prepared. The proper response from a judge to that is tough shit.
Yeah.
Okay. Your experts have an opinion. They're allowed. They go last. Now, they get a rebuttal case, but the defense goes after you. They're allowed, if they're capable of doing it, to attack that. And then what we do is we have these 12 people sitting over there. They're called the jury, and they're allowed to determine how credible or not credible in light of all this evidence is. But to have a prosecutor get up and whine and say, it's not fair, they waited too long, I don't know what to do because I haven't gotten a report, that's embarrassing. And that's the kind of thing that was just a shocking colloquy to see in a courtroom, that they should literally muzzle the defense exculpatory witnesses by restricting them to their initial opinion, but have no right to actually comment on the prosecution's expert and say why they think they're wrong, assuming that's the case. I don't know what the guys would even say, but that was embarrassing.
So much so. Like I as a layperson, right, as just a nurse and somebody watching that, I go, well, wait a minute, that's what every expert does. Like you give, if there's a, that's their job, is to be a what, battle of the experts, and our jury, the fact finders, decide who's weighted more, right? Or what we believe or what we don't. That's not your decision, Hank. And it's very apparent, as you said, it was just an absolute breakdown. And it has been since day one, since the day he took this case and this job for the $75,000 the first round, and then now the extra 225. You know, not a bad payday for one caseload, but I digress. um it really showed the hand. He has said multiple times that he doesn't want to exclude Arca, and he's trying to have a fair trial for Karen Read, and then yet every action and word that he says seems to contradict that in entirety.
Listen, when you're a lawyer, okay, and particularly a litigator, your credibility is everything. That is your only stock in trade, is your credibility. When you see him in a courtroom and the representations he makes and the gaslighting that he engages in and all these other things, he, every time he talks, is losing more and more credibility. Now, does the judge seem to notice or care? That's, you know, maybe not the case. But to anyone who's watching this, you know, whether it be on TV or whatever side you're on, there is something going on here, which just, he is not acting in the role of prosecutor. Okay. Again, a prosecutor is a minister of justice. The role of a prosecutor is to do justice, whatever the hell that means. That is not the role of the defense attorney. The role of the defense attorney is to zealously advocate and represent your client ethically. You can't violate rules, but to go as far as you can within the ethical boundaries to zealously advocate and represent your client and get the best result for them, whatever that may be. In this case, for them, that's an acquittal and they're going all the way. That's fine. The role of the prosecutor is not to win the trial. It's to do justice. And to sit here and say that, you should, I'm not worried about the ARCA witnesses, but, focus on his actions, not his words. Okay. All of his actions are to do everything he can to keep the most fundamentally exculpatory witnesses from testifying.
Yeah.
Okay. And it's crazy. And look, I don't fault him for advocating for his side, but maybe it's been too long since he's been a prosecutor and he just is losing, his role. I mean, the reality is, if 3 years ago, if Karen had called him to represent her on this case, do you not think he'd be screaming and yelling how corrupt the Massachusetts State Police are, how ridiculous crime scene evidence in this, all of that? I mean, look, we all have a role to play. We all have a side to go. But when you are the prosecutor, you have to wear the white hat. You have to do it the right way, especially in a case like this. And every time he makes these arguments, tries to, exclude this type of evidence, tries to, put duct tape over their mouth before they make an opening statement about anything that you saw the other day. This is stuff that you just don't see. Okay. You don't see prosecutors try to pierce lawyer-client privilege for what is a ticky-tack waiver. Now, technically, was that a waiver? What was that whole argument? Probably to some extent, but to assume that you would file that motion and demand to see everything that, behind the kimono between lawyer and client based on that speculation is something that 99% of prosecutors would never even think of doing. In this case, I'm sure it was the first thing they thought as soon as they thought it was, a possible ticky-tack waiver. I mean, it is what it is. And these are questions ultimately for the voters of this county. And, why did you hire this guy? Did you know he was going to act like this? Did no one else want to take the job? Why am I paying for this? When did no one in your office want to do this? I mean, you could go back and forth with all this stuff. Ultimately, all this crap, it's not going to fall on Brennan. He's going to make his money, which he's entitled to. God bless him. Could care less. Good for him. But the loser here is going to be Morrissey to explain the answer to all these questions.
Right. And the shocking thing as well is when we look even further than Karen and Officer John O'Keefe, you find things such as Sandra Birchmore. You look deeper in this veil of what is going on, or what has been allowed to just seem to be, I know these are very extreme examples, but a pattern that is very recognizable. And Michael Morrissey, the buck stops with you, right? That's where it is. The fish rots from the head, Mr. Bederow, and that head hasn't been challenged since 1982.
I was just going to say, I mean, you say 1982. I don't know what the exact years are, but has Michael Morrissey ever had a job in which he doesn't collect a government paycheck since like the 1960s? That's part of the problem. I mean,
yeah.
when you become a just career bureaucrat and hack and just collect off the public dime, you become fat, lazy, and just beholden to nobody. I mean, it's like essentially up until now, he's been DA for life. I mean, that's just the way it is. And nobody questions what you're doing. And it takes these kinds of things. I mean, it takes, obviously, this whole thing with Karen is going to be the one that probably undoes him. But, during that process, you learn about, the Sandra Birchmore thing, which appears so many red flags, which at a minimum should have suggested to his people that this was potentially a homicide and not a suicide. And they just, I hate to use the cliche, but they look the other way. They don't do this. They don't do that. And you see everything else that's going on. And then you question all these years that they've been working with these detectives who are literally encamped in their office, and they're drinking buddies. They go out, they drink with them, they eat with them. They send text messages joking about nudes with them, all this kind of stuff. The whole culture of prosecution in Norfolk County is a shit show, and it's gross, and it needs to go. And if there was no Karen case, I'm not sure anybody would see that.
Right. Absolutely. 100% in my opinion as well, Mr. Bederow. It's been shocking, but the revealing needed to occur, right? Like it's so scary that it had to take something like this for the light to expose what had happened in the dark. And, there will be accountability. I truly believe that. I do have faith, that somebody, meaning saying with changing of positions, voting in new representation, because like you're saying, when you have no one that challenges you and you are just at status quo, business as usual, you can see where things might start to just, corruption or crooked things don't happen overnight. This is a slow, steady, hey, I can get away with this for how long, right?
Career politicians who are not challenged and who are in absolute power and have no challenging and nobody questions them are fertile breeding grounds for corruption. And that's how corruption generally forms. You're not accountable to anyone. So corruption can take many forms. Most corruption is not, I'm going to choose to accuse falsely someone of crime. No, they cut corners. They protect people. They maybe don't do things. They, take donations from employees and things like that. Those are all various forms of corruption. It doesn't have to be to say, today's Monday, what do you want to do? Well, let's just go pin a crime on someone. That's not how it works. Right. They just do things in a way where they become fat, drunk, and stupid. They just don't care. They're not accountable. They do it their way. They protect people, and everyone's too comfortable and calm. There's no accountability. And that leads to various forms of corruption. And that's how you see, a case like Karen, if you accept the defense theory, they weren't looking to just go out and accuse someone of a crime. They had a crime on a very well respected, apparently, town citizen who happened to be a police officer, and the state trooper assigned has some degree of connection.
Right.
It's Canton, which is like the most incestuous town in America, apparently, where no one ever leaves, everyone marries everyone knows everyone. I went to school with this one and that one.
Yep.
And so that's how the corruption takes form. They just subtly protect each other. And that's how it happens. And that's how a lot of people think it happened in this case. And whether it's true or not, because they're all so cozy, because they've all been in power for so long, because they're all so lazy in their professional duties and being by the book, people are going to think that it's corrupt. So they've already lost. Okay. Whether one particular individual committed a crime or not, if everybody has reason not to trust you and they just assume that we can't believe you and believe that you're going to do this honestly, whether it's Sandra Birchmore, Karen Read, or any of these other things, they've already lost. Okay. The damage is already done. There's a large segment of the population that's never going to take any of these people in Norfolk County or Canton serious ever again. So it's time to go. I mean, it's for the greater good, whatever you think about this case. How are they going to function? I mean, it's just a mess.
Yeah. Yeah. And that's it. There it is. That's it in a nutshell. And I think I've said this exact same thing, just in my opinion as well, Mr. Bederow, is that as it relates to that, or, opposing people thinking that, oh, this can't be 75 people that have all covered up. It is not. I've never said that one time. I don't know what happened on January 29th, 2022, because one, wasn't there, and two, I didn't investigate it, okay? I'm never going to have an opinion other than what I believe based on my training and experience and my life experience as a registered nurse, that this doesn't make sense medically, scientifically, or any other rational way that I can look at this to try to do the mental gymnastics to get to where the Commonwealth was.
Right. But if I'm looking at corruption, I don't even need to go there. I'm focusing on the response. Okay. And the response is, here come you start with the Canton cops. They make a determination within a short period of time. We can't be involved because, one of our detectives is a brother of the homeowner, and Lank went to high school with McCabe and Good and this, and they're all, again, it's just like incestuous at every level. And there's some degree of, we need to step away. Okay, fine. But yet when the state police come in, they give it to Proctor, who lives in Canton and who knows these people and was in the wedding party of these other people, seems to misrepresent whatever connections he has. They don't remove him. That would be an obvious thing to do. He's texting his drinking buddies or high school buddies, don't worry about the homeowner. He's a Boston cop. You've got issues about, I interviewed this person and she knows you. How are you doing? All those connections. They're using the Canton Police Department to store the vehicle after they've been removed. They shouldn't really be doing that. Then you start getting to all these conversations and relationships where they're having actual serious conversations about witnesses and town residents saying, I want to buy you a gift. And without missing a beat, just give it to my wife. As opposed to we don't really do that. Just, don't give it to me, give it to my wife. And you go on and on with all of this stuff. And, you ultimately end up with, the DA, the elected official himself, issuing what is probably, again, in my experience, the most ridiculous public statement that has ever been made by a district attorney in terms of, violating the ethical rules of, potentially tampering with potential jurors by talking about, defending all of these people. But it's more than that. I mean, we call it the hostage video in a colloquial sense. I mean, he was giving a vigorous defense of the witnesses as it, and there's no question he was put up to it. And, even, one of the letters that we wrote had some of the exhibits about some of the
Yes.
communication. They were meeting with these civilians and taking their input on what he would say about certain people who are involved in one way or another, whether it's witness, suspect, whatever, with Karen's case. And when you see all of this, putting aside whether you think Karen's guilty or not, there is just so much gross and ickiness going on here with the incestuous relationship between all of these people that nobody recuses himself. And even when they do, and a perfect example is, they say, well, we're going to recuse ourselves from the other case, Aiden's case. Okay, fine.
Yeah.
That's the proper move. But we're kind of burying the lead with this. The state police need to recuse themselves. Okay. They're up to their neck in this. They're the ones that have the problem with him. They're the ones who are alleged victims of him. Tully is the one who is, he's being criticized as this and that. And guess what? They're still the ones doing it. They're still involved in the case. So the conflict is what? 50% addressed? None of this makes any sense. I don't know why anybody would have any confidence in the ability of these people to do a fair and independent investigation when they so easily could have been removed. And obviously, the federal government agreed. And now I don't care if their conclusions were or will be whatever, but the fact that they looked into that tells you that was a concern of theirs too. The fact that they took a suicide determination in the other case and turned it into a potentially capital murder indictment. It's not, I mean, obviously none of that's going to happen in this case, in Birchmore's case. But the fact that they had to do their own independent investigation and appear to have a pretty solid, at least based on the evidence that was released so far, very solid indictment in that case tells you the federal government doesn't have any confidence in the Norfolk DA's office to do it. Why would the public?
Yeah, they couldn't. And correct me if I'm wrong, it's not even a conflict that needs to be a tangible or real, right? It's an appearance of impropriety that you are to recuse yourself from. So in my opinion, that hasn't occurred in Norfolk, in the Norfolk County and or that Norfolk DA's MSP, their specific tribe, troop, whatever, F or whatever it is. Fanning was asking Matthew Farwell, just in the Birchmore case, just sat him down, Mark, and said, hey, you didn't do this, right? Asked, I mean, there's no recordings. There's, there's things that are just horrifying.
Now, if I'm wrong, because I'm not an expert in that case, but my recollection is his report in that case, he didn't do a formal interview of Officer Farwell. He had a conversation with Matt. I believe he was Matt.
That's what he wrote. Yeah, you're right.
Oh, Matt. And I believe that was sitting in a police car shooting the shit or something like that. Not a you need to come down here. And, that's what investigators do. You assert control, okay? If you're doing this on the up and up, you assert like there are boundaries and this is a formal thing. And sitting in his car, chit-chatting, talking to a guy as Matt, and then it turns out, they miss all these messages, they miss all these other warning signs, suggests, again, that they're too chummy, and this whole area, whether it's the town of Canton or the county of Norfolk, it's just too comfortable and incestuous. There's no other word for it. That's what it is.
Right. And
it feels like 1950s Alabama in Greater Boston, and that should not be the case.
No, it should not. No, it should not. Not in the year of our Lord 2025, okay? But it is markedly ass backwards and very, very twisted and needs to be like you always say, it needs to be fumigated, right? You're always like fumigated. And that's how I feel as well. And even as somebody who is very pro law enforcement, has mass police officers active in my family, retired, some of the first in our state are my family members. It is a nightmare. And there are things that culturally cannot be accepted moving forward.
Mhm.
Period.
Yeah, I agree.
Yeah. Now, I have a question for you about opening, okay? And I know that you if you were a guessing man, not based on any, actual feelings or knowledge, would you be safe and steady with your opening for the defense, not the prosecution? Defense opening, would you go within the guardrails, or would you go 100% for the gusto if you were in?
Oh, did you freeze? I lost you. Oh, are you back? I
I'm
lost you.
here.
Okay, I lost you.
I'm sorry.
Okay, would I what?
Oh, I was saying, would you, if it was your, sorry, I'm just turning this off to see if the Wi-Fi, I am plugged in right now and it is still hating me. If you were delivering an opening argument, would you be safe, or would you go for the gusto and literally just knock it out of the park, Mark?
It depends.
Oh,
I mean, probably somewhere in the middle. I mean, the first thing is this, and this is part of the handicap they have with the way the rulings work in this case. If you're gonna go for the throat, so to speak, and you have evidence that you believe you're going to introduce, you better be damn certain it's admissible. So when we hearing about, well, I haven't decided on ARCA or whatever, what happens, if you try to open on that and she doesn't allow it, you're kind of screwed, right?
yeah.
There are certain disclaimers. The other thing is this: you never want to assume a burden that you don't have to. And, do you accept the possibility that the prosecution's case could implode based on your own cross-examination or whatnot? So there may be times that you don't want to reveal all. Having said that, yeah, I would open on the ARCA stuff and reasonable doubt, and that you need to make it clear, not so much that she was framed, that's a part of it.
Yep.
But what if you want to pound home one fact above and beyond everything in this case, it is that a Lexus 570 or whatever the hell it is, operated by Karen Read on January 29th, 2022, backing up 25 miles an hour into John O'Keefe, did not happen. Ergo, ipso facto, the evidence will show, they can't satisfy their burden of proof. She didn't do it. Okay. And that's the one thing, and all will flow from that. And so
Perfect.
if you assume that Brennan will open on, the strong evidence of all of this taillight that was recovered at the scene and well, then, yeah, you're going to open and say, well, ladies and gentlemen, pay real attention about how that taillight got there and when it was found. And you're going to learn all these facts that are going to make you be very, very suspicious about that. Again, there's different ways to do this. But I would be aggressive in the opening, but I would focus it a little differently. By the way, the opening, the last one was really good. I love it, but I wouldn't be so locked down on framed as much as the science is going to tell you that she didn't do it. Now, again, not being present for voir dire, and of course, in this case, the judge not really allowing them to ask questions. One of the things that, from a defense side, you would be voir diring on is you want people who trust science, because that's how you're going to win.
Yes.
You need people who are like again, my thing for jury selection is brainwashing and getting rid of the kooks. Part of the brainwashing is I need people that are going to understand that's that ARCA is credible and get
Yes.
rid of other whack jobs. Now, so I'm going to assume that they did all that. So yeah, I would open on all that stuff. Sure.
I love that. And of course I'm going to do tomorrow night. I'm going to do a little mock, like just a my opening if I were, just to see if I'm anywhere near, because I don't have any insight into anything other than covering it very closely for as long as I have. And I have like a safe one, and then I have one that is, swinging for the fences, if you will. But
you can swing for the fences and focus on
yeah,
reasonable doubt. You don't have to go all promising all this. You can say you can work off the DA summation. And again, real trial lawyers, just again, yeah, you're going to sketch out some notes, you're going to make bullet points, but skilled lawyers, and these are skilled lawyers, you have to be flexible. You got to go off what he says, and you're not going to have time to go home and prepare it. You've just got to react in real time and work off what he says.
I love
that's
that.
That's the one time it's the only time really in the trial that the defense gets the advantage of having the so-called last word. Okay.
Yeah.
So that you do have the ability to work off and highlight things that he said that you want to hit or, use to your own advantage. So that, you do have to be flexible and be able to think on your feet and process and make judgment calls on the fly. Having said that, they will be prepared, obviously. Most lawyers would do like more bullet points than writing out, literally word for word and get stuck in that where I'm flipping pages and where did I, you don't want to, it's too much of a crutch.
You need to have I feel, and even like if I'm like doing when I go to wound conferences and I'm presenting and I'm a keynote speaker, I just have to have my literal bullet points of where I'm going, because I have to read the room. So I assume you guys are reading clearly the jurors, right? You're seeing what the body language is, and you've got to see where something struck a nerve. You can see how people are reacting. Even if they're not reactive, you can read body language and even non-verbal cues, such as somebody like maybe like, I don't know, tapping their foot more than once or whatever, so there are things that you can, clenching your jaw is another, so you can just watch people and really see.
And one of the shames of this is in my view, just shameful way they did jury selection, doing one at a time at the bench. If you did it the traditional way, you put a bunch of people in the box, you're having conversations, you're working from juror A to juror B to juror C, but also, to your point, you're seeing how the rest of the panel is reacting to what's being discussed. And body language is a tell. I mean, more than words. And eyes get rolled, head shake, people laugh, they cry, they whatever. And it's a huge thing to be able to see not only the juror you're talking to, but if you're having a conversation with a prospective juror about, a point, and you see someone else like furiously shaking their head no, you're going to take note of that, good or bad, what that may mean. And in this case, they had no ability to see the panel as a whole, to use their peremptories in a strategic way. Do I save it because this one's not as bad as this guy coming up down the line, that kind of thing. And that's the thing that would scare the hell out of me more than anything else, is the way that they were just handicapped during jury selection, and you just hope for the best.
Yeah, 110%. Now, also, what do we think, or I don't recall if there was a motion in limine, because we still don't have all the motions in limine returned, but with regards to ARCA not being able to say, they weren't able to say that there was the FBI, the federal investigation in 1.0. What do we think for a workaround with that, Mr. Bederow, in the event that Judge Cannoni does not allow them? Well, but now if there is not an FBI investigation, if it's closed, why couldn't they say FBI investigation? Because that's usually only for open matters. I was under the impression that they wouldn't be able to.
At this point, I would allow the FBI investigation to come out. It's more forthright. It's more candid. It's also easier for the witnesses to not sit there and
Yes.
but there are rules to the game. I mean, the whole theory in the first trial, and by the way, this was a proper ruling by the judge to not allow it. There would have
Correct.
been no question and overemphasis by the jury to say, oh my God, how could they try her if the feds think? So if you allow the federal investigation in this case, it would be, in my view, totally appropriate to allow the DA to also establish, at least for now, assuming it's true, nothing has come of that. Now, the problem with even doing that is there has been no official word from the Justice Department that is closed, because that's not what they do.
Right.
There has been, information released by the chief of the Canton Police and, people on Twitter. But the concern I would have is that's not a good enough source for me. If you don't hear it from the actual people that are doing it.
Right.
But if I were the defense, that's a trade I would make, because I'm not concerned that the feds didn't charge anyone, because what the feds do is they don't arrest people and charge them in crimes unless they have overwhelming proof that they did. And
Right.
I'm not here to tell you there is any overwhelming proof that anyone other, from the prosecution standpoint, did it, other than Karen. That's their view. I'm not here to tell you that there's, compelling proof against Brian Albert and Brian Higgins. There is compelling proof that they engaged along with others in very, what I would call incriminating and suspicious conduct after the fact of
Right.
1240 that is very suspicious. Does that prove that they were involved in a murder? No. Why are they butt dialing back and forth? That's suspicious. The text messages they sent, the Google searches, all that, that's suspicious. But I can understand why the feds would not, or they shouldn't arrest them just based on that. But
Yeah.
I would take that trade, if that's the right term, to get it all out. It was the FBI, and the Justice Department, and that they, closed the investigation with no action. That doesn't, that's not a perfect outcome, but you can't be in a situation where you have the jury speculating on who hired these witnesses. I mean, when you hear about, a juror who was interviewed, and I know now has been on many, many, national TV shows at this point, talking about, we didn't know who hired them, and we thought it might have been somehow affiliated with the defense. That's not good. So
Insurance too. That was really the kicker for me.
at a minimum, you've got to allow the defense to establish, and really what the prosecution should do is stipulate to this, that it was hired by an independent, unnamed government agency that had no affiliation whatsoever or knowledge of the defense or prosecution. You have to make it fair, but you've got to also make it very clear, because, we could be going down this road to crazy town, at least based on what Brennan represents in court, that he somehow thinks it's a very big deal that they got paid this pissant sum of $20,000 after the trial was over, and that somehow colored their opinion that was given 2 months before they even knew who Karen Read was.
Right.
I mean, that's just beyond dumb. And I don't know a single prosecutor who would go down that line of argument. I think at this point you're going to see it in this case, because what the hell else are they going to do?
Right.
And they're going to try to say, like Wendy Murphy said on Twitter, that, they're corrupt and will never get hired again, the ARCA people. This is all so profoundly stupid, but you've got to allow the defense to have it out there that these were independently hired. Now, if you want to argue that they somehow rendered an independent opinion and then somehow got turned to the dark side because, Team Karen dangled $20,000 in front of them, notwithstanding their probably several $100,000 bill that they got from the Department of Justice,
Yep.
then be my guest. That's not going to be a very persuasive argument, but the jury has to know, as part of a fundamental fairness, that these witnesses are not classic experts hired, like the argument they're going to make about all the other defense experts, that they're
Yeah.
basically hired whores. I mean, that's what they're going to argue. Doesn't make it true, but that's what they're going to do.
Right.
Let's call it what it is. Okay.
Right.
They're going to argue that Dr. Russell is just a hired clown who immersed herself from California because, she did this, and her, she lied about the length of her subscription to the Boston Globe. So therefore,
You got her.
she's a hired hack. All these other experts are going to be, they dangled money in front of them and they'll say what they want.
Yep.
It's just the way it's clear they're going to argue, because they're trying to say that about the ARCA people, who are the quintessential disinterested in the beginning anyway.
Of course.
Who were simply asked to give the federal government an opinion to let them know, are we going even down the right path here? I mean, now the bottom line is the federal government didn't charge anyone, but they obviously don't think there's evidence against Karen that warrants prosecution either,
Right.
based on all the evidence that they gathered. And again, if nobody is able to be prosecuted here, then Karen shouldn't be sitting at the defense table.
Yeah. Yeah. Yep.
That doesn't mean Brian Albert should be, but that's not the issue. She's the one on trial, in my view anyway, and I think based on many people's views of the evidence, this is just an exercise in, I don't want to call it silliness, because nothing about this is silly, but as a legal exercise, this is just in many ways beyond the pale.
Yes.
I mean, ask any prosecutor, former prosecutor that you believe has integrity and ethics and whatnot, and I'm pretty confident that virtually all of them would tell you this is just too much. They don't have to tell you they think she's innocent. They just say the prosecution's wrong.
Correct. And if your case is flimsy, worse the second, flimsy at best the first trial, circumstantial with what we had taillight would be the only thing that connected Karen Read or her vehicle to 34 Fairview that was found for 3 weeks after a snowstorm, but not one piece found in the beginning stages of a blizzard on January 29th, 2022, while Lieutenant Gallagher was methodically removing snow layer by layer, found droplets, 3 droplets of blood, Mr. Bederow, but couldn't find 45 pieces of taillight. I'm going to need you all to F off.
The problem is, and of course, I mean, that makes perfect sense, but it goes back to why the public should have no confidence in any of these in the Norfolk DA's office. If you want to give them a mulligan for putting her, through the ringer for all this time, the line to draw in the sand when you should have no doubt that this is not an exercise in seeking justice as much as get her, okay, was when the feds dumped the material, okay? Because I'm here to tell you what any sensible prosecutor would have done at that very moment, okay? Upon reviewing that material, they would have fallen out of their chair. I don't care how guilty they think she was at that time. They would have at least recognized, upon seeing the ARCA stuff, wow, that should, if nothing else, give me pause and concern to say, did I fuck up here? Pardon my French. Are we going down the wrong path? What they should have done at that time was, now this judge, would she do it or not? I don't know, but called a timeout, okay, and said, Judge, we have come into some information. We need time. This is a potentially case dispositive thing. We need to satisfy ourselves that this is the right thing to do. Yeah. And what any reasonable, sensible, and ethical prosecutor would have done at that point was taken a deep breath and made a complete reevaluation about every premise that they based this on. And when they saw that on top of the ARCA stuff, they learned about, they already knew about Proctor, or they were learning about all that, they would have connected those dots together and said, that's doubly troubling. Okay. Because now we have a guy who's clearly inappropriate, suggesting bias, doing really bad things, who is at the center of what the defense is alleging. And now we're being told, there was no accident. And then what a sensible prosecutor would have said is the taillight pieces. This is a problem for me, at least to the extent we need to satisfy ourselves we're on the right side of this. Because the problem with the taillight pieces is, you have the first couple of pieces, like you said, they didn't even see. Then you have, the CERT team, which is the wrong search team, by the way, as opposed to the crime scene people.
Yeah.
So you're relying on Tully's word for what was recovered and when. No names, strangers, 5 unaccounted people at the search. They're finding stuff that's allegedly buried under snow in like record time. They find 3 tiny pieces and then say, that's a wrap. We're out of here. No need to come back. And then they find the other piece over the course of the next couple of weeks because it reveals itself. And any sane investigator and lawyer in the DA's office should have said, I call bullshit on that. Okay.
Yeah.
No sane DA or investigator who would say the proper investigative strategy was, well, we're going to wait for the snow to melt and do this. Meanwhile, how do you know the homeowner's not doing something? Okay.
Right.
You don't know. I'm not saying he did or he didn't, but you don't know. There never was a preserved crime scene. And certainly there wasn't for the 2 weeks where they found all the evidence. Then they stopped taking pictures of the evidence. They didn't take pictures of the taillight. They didn't do this. They didn't do that. At a minimum, when they learned about all of this, they should have at least gone after Proctor with his lawyer and said, we have questions. Like this, we need to know. They should have done this with his colleagues. They should have done this with Berkowitz, who claims he found the taillight piece. They should have done all of these things. And instead, what they did was they marched back into court, okay, and had this McLaughlin stand up and tell the judge with a straight face that we've reviewed all of these materials. And I'm paraphrasing here, but there's no exculpatory evidence in this, okay? The amount of exculpatory evidence in that TUI disclosure was suffocating, okay? The ARCA stuff in and of itself is just over the top favorable to the defense. These prosecutors are aware that credibility evidence that destroys credibility of witnesses, is also considered exculpatory and favorable. All the stuff they learned about Proctor, all the stuff they learned about, the messages, the butt dials, that's all favorable, all of it. And I mean, when a prosecutor's experience comes in with a straight face and says there's nothing in there, you can't take them seriously. You can't trust them. You can't take anything they say. So what they basically do is when they get these materials, they just shrug their shoulders and say, whatever, what are we getting for dinner and when's trial starting? And again, I'm here to tell you that's not what real prosecutors would have done. Now, is it possible that if they had done that and come out the way they did, I don't know how they could, but I would at least respect that they recognize this is troubling. They don't even think it's troubling. And at this point, they're fine sending Brennan to court with a straight face to look at the world and say, ARCA are biased witnesses who are in cahoots with the defense and the feds to screw over the Norfolk County DA's office. Now, I would ask you, who's wearing the tinfoil hat now? Who sounds like the conspiracy lunatics now, right? This is absolutely ridiculous.
Agreed. Now, speaking of Trooper Proctor, now that we have, I just was hoping to get your take, Mr. Bederow, on over under him pleading the fifth, because he's now in my brain, and I could be completely off gear here, but I'm thinking if he is civilian Proctor, he is no longer Trooper Michael Proctor. And I'm not saying that there's nothing open or I have no idea, but could he in fact incriminate himself by answering or having all this information be ginned up again when he is trying to appeal his dishonorable discharge by the Mass State Police, and B, you know, he may not be looking too good, generally speaking, after this is all said and done. Do you think he could at all plead the fifth?
No, the problem is that it sailed. The time to do that was the last trial. He's waived it. He's already given sworn testimony about everything at issue, which is why I said before the first trial, how in the hell is this guy not taking the fifth? He absolutely should have taken the fifth before the first trial. But he has answered under oath everything. So that his right to do that is kind of gone. Okay. So, I mean, nothing he would be examined at this case would really be new. It would all be related to his testimony that he testified about. Now, the problem that he'll have this time, if he were to testify and taking away the Fifth Amendment issue, is now he's been terminated. There are findings, and one of those specifications is literally for potential bias in this case.
This was,
in which the defense is accusing him of being corrupt and biased. I mean, that is a perfect storm of bad for the prosecution. The other problem he'll have is, you know, Brennan, Lally, and McLaughlin decided when they answered their motion to dismiss to make Michael Proctor, he's not worthy of the title trooper anymore, obviously. Mm-hmm. And the cross-examination for 10 minutes, you could play with that. They made him the useful idiot and the patsy for all of the Sallyport stuff.
Right.
Okay. So the problem, if he testifies the second time, they've left it on Proctor now to explain the impossible, which is, I had all this video from the Canton Sallyport, and inexplicably over the course of 2 years, talking to Lally every day, talking to whoever, talking to Morrissey, doing whatever it is, I just never said a word such that the people in the DA's office had no idea. Now, first of all, I don't know who really believes that. I don't believe that, but that it's either here or there. The bottom line is that's their position. So when the defense is arguing again that this is a cover-up and there's inverted video and there are shenanigans going on in there, and that any video that does show up that ought to show the real taillight, it's all jumbled and our time is missing. And then if it's not already bad enough to come back to Proctor, now you have this new nugget that presumably he's the guy who's going to have to say, well, you know, I had that video the whole time. I just didn't tell anyone. So he is the albatross, is the word I've used for the DA. I mean, they're damned if they do it. They're damned if they don't.
Right.
If they don't call him, the question then becomes whether the defense will. But either way, you don't call the lead investigator in a case like this. And then the defense is going to make hay with the fact that they didn't call him because he's a disgraced scumbag who was, you know, accused credibly of having actual bias against our client. So, you know, one theory is if you're the DA, you put him on the stand, you hold your nose and just let him get absolutely, you know, death by 1,000 cuts, right? Just sliced and diced here, there for an hour, and then he just is destroyed. You could not do it, and of course run the risk of the defense saying, guess who had to call him? We did. Why didn't they? And then hope that if the defense is forced to call him, that they have to direct examine him rather than cross him, which is much harder, much more difficult, unless the judge would allow him to be declared hostile, which I'm not sure she would do, as long as he's answering the questions and not being cagey.
Okay.
I mean, but the time to do that was before he testified to the exact same things that he would testify now. So that's not really an option for him. And that's between him and his lawyer as to why they didn't do that before. But I'm also told that, you know, you can't take the fifth because that, you know, according to Wendy and Julie and Coffindaffer and everyone else, that means obviously, you know, you're guilty. So, you know, so Proctor couldn't do that apparently. Whatever.
Correct. And then just two more questions, just two more, if you don't mind, with me, Mr. Bederow, just that I was wondering. How about the part of the reader, as requested by one Hank Brennan? I have officially submitted my tape to the Commonwealth, to Judge Cannoni and Alan Jackson to be in the running and consideration. But what in the actual fuck, pardon me, was that all about? Why wouldn't we
I
just
think,
have Nick Carino?
well, the obvious answer for some, in the sense of what people may be thinking, I don't know what the answer is. Are they trying to, kind of wrap Guarino up in bubble tape and hide him in the closet and hope nobody notices? I don't know if that's the reason. The idea, though, that they need witnesses to come in repeatedly again and again to do this, to me, is an absolute joke. It's not necessary. I'm glad the defense was opposed to that. The bottom line is, the person who discovered the evidence is more than capable to say, this is the evidence I discovered, assuming all other rules of admissibility and hearsay and whatever don't preclude any of this coming in. I totally credit the point that I think was raised by Alan about voice inflections are a concern. That can influence a juror, tone of voice. Now, if somebody's reading their own messages and they say, well, that's how I interpreted it and whatever, I give a little wider berth. Like, when you had the famous Higgins, like 3 hours of reading text messages, I mean, you just have to kind of sit through that and get through it because it's that torturous and painful. But
did you see my portrayal of Higgins? Me as Higgins?
No, but I guess my point, there is no reason whatsoever that they need to call witnesses again and again, now reading the part of, this person is this, and what, now you're going to start getting men and women, and what if people don't like that and say, why does it have to be a man or a woman? All kinds of things. This is crazy. Just, there's no reason for this. Now, does the judge have the discretion to do it? Probably. I mean, this is not the kind of thing that is going to be reversible error. Will she do it? Probably. But I think it's wrong, and there's no way that this is needed or necessary. And to be honest with you, at this point, anything the DA wants to do in this case, if I'm the defense, I'm skeptical and I'm objecting for a very simple reason. I don't trust them.
Amen.
Period.
Ever. Yeah. Yeah. And Judge Cannoni did seem like she was up for it. Just in hearing her, she was just like, well, wait. He was saying that he didn't want any inflection. And the argument from, we know, Alan Jackson was, yeah, you say that, but unfortunately, I can't trust you by any of the shit you've said. No offense, but like, you keep telling me it's one way, and then another thing happens, and this he's not willing to concede. Why? Because that's in front of a jury, and then you can't put that genie back in the bottle.
That's right.
Right?
No, yeah. I mean, do I think she'll do it? Probably. But I think they made the right argument in terms of opposing it, what they said in court. I know they filed some response maybe a few days ago. In full disclosure, I didn't read that. I haven't seen that. But I mean, I'm sure it was more the same of what they said in court. And I'm sure this is not the kind of thing that comes up. I mean, the other problem is this, and it's one of the general problems with this case. Every single thing is just, motion, response, hearing, motion, response, hearing. And, I made a joke last week. We're waiting for the, motion to take a 5-minute pee break, and then someone's going to have to file a response, and then you need a hearing to determine whether they're going to allow that to happen. It's just
right.
The whole process of this case, like as a matter of organization and litigation, is, I mean, I don't know why this can't be done in a conference call with the lawyers, a meeting with the judge, whether it's in chambers, the jury room, by email. Like, I just don't understand why every single thing is formal motion, formal response, and hearing and whatnot. And, you may find this funny because I get criticized for this, but, in New York federal court, everything is done with letters.
I love your letters. I love your letters, Mr. Bederow.
So the federal judges in the Southern District, but that means nothing to the Twitter people in Massachusetts. So,
well, well, look I just found something in my pocket for anyone who needed to. Whoops. Okay, there we go. I sent it to them. And they can read your letter. So, and the final thing I wanted to ask you is there has been a lot of like non up to par, or people not up to par, I don't mean it like that, but people that were not interested, that are newly interested after the ID, after this coming up on Good Morning America or any kind of, it's national now again as we are heading into retrial. There's been a lot of boys that didn't know about this case that I deal with online and in real life, and they are saying that that they couldn't convict Karen if they were on a jury, but that they don't know whether or not she did it. But I say at the end of the day, reasonable doubt, that's a good thing, and they know better of that. Like, I would have to vote not guilty. I don't care anything else, boys, just use your brains. But there's been something that's like shocking to me coming up is, Kim, this is probably going to be a hung jury again. And but they were under the impression that Karen couldn't get prosecuted for a third time. And that is not the case in the Commonwealth of Massachusetts. And actually the DA's office has said, or not the DA's office, rather the O'Keefe family has said that the DA's office told them they would continue to prosecute this. Is your thoughts kind of on this, Mr. Bederow, that if it was a hung jury, would they prosecute again, in your opinion? And do you think that there's a real chance of that, or that we'll get an outcome this time?
Well, there are external factors that would come into that. The most obvious one is, who's to say Michael Morrissey gets to make that choice and he's not thrown out of office and out of here, and somebody new comes in and gets to wear the big boy pants or big girl pants, as it were, and decide what to do. So that's the first just real life thing. The other thing is what a sane prosecutor would do is say, if there's been two hung juries, I'm not saying you should or shouldn't do a third one, but that's a red flag that, like, maybe we don't have it. Okay. The next thing that, again, a sane prosecutor would look at are, where is it coming out? I mean, she got, for all intents and purposes, acquitted of 2 counts. Forget legally, that's been decided, whatever. But you've had 5 or 6 jurors come out and say, that's great, she was not guilty, and we all agreed. That's something the DA should factor in. And again, what a sane DA would factor that in, and wouldn't even be charging her with murder right now. They would dump that charge. But, that's not how they do business in Chinatown, as you know. But if they were to try her again and she got, if it's a hung jury, but it's like 11-1, 10-2 to acquit across the board, or they acquit on 2 and it's, 8-4, not guilty on whatever. In that situation, most sane prosecutors would say, I can't justify doing this again, given the harm to the community, the taxpayers.
Yes.
What are you going to do? You're going to say, Brennan, you want to do it again because you did such a great job? Here's another $1 million. Go at it. But there are so many external variables. There does come a point in time where a defense will file a motion attempting to preclude another trial, and they probably would file it if there was another hung jury. I'm not saying that would be granted, but there does come a time where the argument does get strong to say that, this can't continue, and it's becoming, a violation of her rights and whatnot, under various provisions of the Constitution. But the fact that they're telling the family, we'll do this as long as we have to. I mean, I get it. That's what they're supposed to do, I guess. On the other hand, you could say, if they're starting a second trial, why are they even talking about the possibility of there being anything beyond this? It's not, that's not a good sign. I mean, I don't think that there'll be a hung jury again, but who knows? There is so much external influence on jurors in this case, which is very problematic. It's just the reality of the world. The same way that the jurors who may be sitting there Tuesday and are told that Karen is being tried for murder, I would imagine one or more of them is looking around in their head saying, wait a minute, those are the charges that those jurors, like, they've been arguing that she was already acquitted. Now,
Yeah.
if I'm a juror and I keep that to myself so as not to poison other jurors, but then they ask me to deliberate a murder charge, I don't know if in good faith. I don't care what you're telling me. I go back in my own conscience, beyond a reasonable doubt to a moral certainty, as they say in Massachusetts.
Mm-hmm.
I don't know if I'm sitting in that jury room saying, I know, based on the reality of what's been in the news from several people, that they essentially acquitted her on these counts. And they're asking me now to basically say, yeah, whatever, find her guilty. That's asking a lot. And it's once again stunning to me that they would even put jurors in that position and not just go forward on count 2, which, by all accounts was a hung count, streamline the case, fine tune it on that, and just trim the fat. But everything that I think a sane prosecutor would do, they just seem to do the exact opposite.
Absolutely. And guys, we love you so much. And I just wanted to say, listen, when I ask a question that's like a question that's terrible, that you're saying to yourselves, we don't want to hear about it being a hung jury and she's going to get acquitted this time. I hope that if you watch me or Mr. Bederow, that we are always going to shoot it to you straight. I call balls and strikes. If there's something that happens well for the prosecution, I'm going to say, hey, that was good for them. And if there are things such as maybe like extrajudicial statements or anything else that I don't think necessarily looks incredible for the defense, I'm going to tell you, because I hope that you know that you trust me, and that's what I do. If I have a medical opinion or an opinion, I'm gonna say it, and so will Mr. Bederow. We hope, and I think that this is a better position for Karen, in my humble opinion, with the now 3 years of Sally Port exculpatory video coming out. We've got a disgraced former trooper, Proctor, who has lost his job. There are a lot of things in the plus column for Karen that we did not have in 1.0. From your lips to God's ears, I'm praying for an acquittal as well. But I just want you to know that your integrity matters. And I'm not going to just say that everything is perfect all the time. Right, Mr. Bederow? I can't say, wow, this is Skittles. Every day, everything looks perfect, right?
No, I mean, look, I think if you're going to be an analyst in any capacity, a host, whatever, whether you have a side or not, again,
right,
credibility is the most important thing. And if you want to cheerlead, if that's the right term, that's fine. But you have to be honest to the analysis and the evidence, and just call it what it is. Otherwise, you just have no credibility. So I don't think it would be, certainly, again, from a lawyer's perspective, I don't think coming on and just waving a flag would be productive. You have to support your opinions, with analysis. And if there are things that are not great, for your own credibility, that's it. I mean, like, I've been very outspoken. I think the HBO series was an unmitigated disaster. I mean, that was just a mistake. I mean, it came off terribly. I don't think it's going to move the needle in terms of actually impacting the results here, but it's a headache that you don't need coming out right before the trial. But yeah, you have to call balls and strikes, and otherwise just come out and say, I'm here to cheerlead. You know what I mean? If you want to be deemed credible, you have to call it as you see it, whatever it is.
And you are the most credible of them all. You are incredible, and you are a friend, and you are a person who makes this very difficult time, and like, just gearing up, I having a little bit of anxiety just myself, and I can't imagine what the O'Keefe family and the Read family feels, especially Karen. Just trying to muster all the strength, and that's why we keep doing what we're doing, and just being there as a part of some kind of support in which we can, right? And that's for me and the community, not meaning Mr. Bederow. You just give me your time, and I appreciate that too. I know you're not on any side. You are just a legal eagle, if you will.
Yeah, I mean, look, I mean, I'm obviously sympathetic. I mean, I think Karen is not guilty. I was going to help establish that, obviously, so I'm biased in that sense. But the key isn't your sympathies; it's the analysis. Just
Right.
if you're gonna open, just be a straight shooter, whatever it is. That's all.
Yeah. Absolutely. And thank you so much. I appreciate you for coming on with us tonight. And like, you have calmed our nerves. You have just thrown out some incredible analysis, as you always do. And I appreciate you, Mr. Bederow. I hope that I get to have you on, just to shoot the breeze with me a couple more times. That would be amazing. Whenever you are available, you're the boss, I'm the horse. And I have one other question. Will you be up at all, like, for anything for Aiden's, that maybe you and I can go to the Kowloon together?
Yeah, I mean, he's going to have court appearances. It's just a matter of what they're for, and my own schedule. As you know, I don't come in for everything because it's just travel, and I have things to do out here. Having said that, the last few that I've missed have been the interesting ones, but it is what it is. But no, there are times that I'll be out there. And I'm sure there's at least once I would pop in and, watch what's going on here. And there's all, I mean, if I come out there, there's always time for Kowloon. Come on.
Well, that sounds like a plan to me. And thank you so much. I really, I wicked appreciate you. I love your face, and I will see you soon. So I'm going to let you go, and I'm going to say goodbye to everybody.
All right.
Good night, Mr. Bederow. Lovies, first and foremost, I apologize. I just said I love you to Mr. Bederow. I'm going to go cry in the bathroom because it was like I was getting off the phone. I don't know why I'm weird. I'm weird. Okay. Well, we love me. I love you. Thanks for answering my FaceTime. And so listen, lovies, tomorrow night I'm doing the mock opening. I'm going to do my mock opening, and then on Tuesday, I'm streaming opening statements. I know you've got other places to be, but I'm going to be talking all the shit. So if you're available, I will be there. And now I need to go and think about my life and say a prayer. Okay? In the name of the Father, and of the Son, and of the Holy Spirit. Happy Easter Sunday, lovies. Bye-bye.